All right, let's get started. I am delighted to introduce this rock star panel. My name is Donnie Gewurtzman. I teach constitutional law here at New York Law School. I'm going to briefly introduce the four gentlemen directly to my left. It is going to be a brief introduction. Dave Posen is the Charles Keller Beekman Professor of Law at Columbia. He is a regular contributor to Jack's blog, Balkanization, as well as the author of a terrific recent book called The Constitution and the War on Drugs. Hank Chambers is the Oliver Hill Faculty Research Scholar at the University of Richmond School of Law. He has written extensively in many areas, particularly in the area of voting rights. Sandy Levinson is the Garwood Centennial Chair of Law at the University of Texas at Austin. He is the author of approximately, and I think I'm getting this number right, 450 articles, books, reviews, or commentaries. And he is also a regular contributor to Balkanization. And last but not least, Michael Higginbotham down at the end there is the Laurence M. Katz Professor of Law at the University of Baltimore School of Law. He has also written extensively in constitutional law, particularly in the area of race and the law. The title of this panel is Constitutional Crisis or Rot: Analyzing the Current Moment. I expect we will continue the conversation that Mario started earlier. I'm going to ask the panelists to please kind of stick to the 12-minute mark around there because we want to leave plenty of time for conversation. With that, I am pleased to turn it over to David Posen.
Okay, great. Thanks so much. It's great to be here. And, among his many scholarly virtues, Jack has a knack for coming up with concepts and labels and frameworks that stick around and shape the way we talk and think about big issues: ideological drift, living originalism, cultural software, nested oppositions, and now we have constitutional rot as another entry in the Balkanian canon. Along with Sandy, Jack had already theorized and taxonomized the more familiar concept of constitutional crisis, which Mario spoke of. And at least to my mind, he's persuasively argued that our current moment is not really marked by constitutional crisis, either in the sense of high-level officials openly refusing to abide by the Constitution's commands, or in the sense of officials claiming they can't address a looming disaster because of the Constitution's constraints. Rather, the more illuminating and more troubling diagnosis is one of rot, which places the emphasis on these longer-running processes through which the systems become less democratic and less Republican. So I accept the framework and find it powerful, but I think it's ambiguous in a number of respects what we mean by constitutional rot. And with my remarks, I'll just try to raise four sets of questions about the phenomenon. So the first is, what exactly is constitutional about constitutional rot? Sometimes Jack seems to equate it with democratic backsliding, but presumably there's something distinctively constitutional about constitutional rot, or else we wouldn't need a new label. And yet, none of the four horsemen of constitutional rot, in Jack's terms, these are the four main causes he identifies of rot. Those are increasing inequality of wealth, increasing polarization, loss of trust, and a decline in ethical political behavior. None of those four horsemen are clearly constitutional in nature. So what is the relationship between constitutional doctrine or design and constitutional rot? And what do we gain by recasting the phenomenon or glossing the phenomenon of democratic backsliding in constitutional terms? Is this just a kind of constitutionally inflected account of democratic backsliding, or is the Constitution and constitutional rot doing more work? I'll come back to that. Okay, second set of questions I have about constitutional rot concern how we would know. How would we know when we're having constitutional rot, and how much? So the rot diagnosis, as opposed to the crisis diagnosis, would suggest that it was happening under Obama and Biden too. It's a long-running phenomenon, and not just an artifact of Trump. And there are some indicia that clearly support that way of seeing those presidencies, including measures of polarization, which continue to creep up under both. But both President Obama and President Biden were not norm breakers by temperament. I think they sincerely did try to serve the public good. They both supported and produced policies that were meant to be more responsive to the needs of ordinary Americans. So did Rott get better or worse under Obama and Biden? And to what extent is this a bipartisan story or really a story of one party, the Republican Party, drifting away from core Republican commitments, small r Republican commitments? More than that, how do we fix a relatively objective baseline from which to measure rot or decline? So in the Democratic backsliding literature, this can be fiercely contested. And you have plenty of conservative critics who say that what liberals like to call backsliding may be quite the opposite. It may just reflect their preferred conception of democracy or policy. And so it's striking that some of what we might identify as core aspects of rot under the current Trump administration are characterized as something more like renewal by the Trump team itself. So when the unitary executive theory, they would say, I think, is healthy democratic correction for excessive power to deep state administrators. Birthright citizenship, I think they would say the efforts to restrict that are actually deepening our commitment to the relevant members of the polity in their view. Voter ID laws are a big point of contention in the Democratic backsliding literature because, again, the Republicans would say they're perfecting, not corroding democracy when we put them into place. And there's a deep concern here that the very polarization, which on Jack's account fuels constitutional rot, also makes it impossible to achieve any consensus about whether there is rot, because the two camps will have very different accounts of what's happening, and what we call rot, they may call renewal, and vice versa. Okay, so how do we know when there's rot and how much rot, how to measure it, how to overcome polarization in that effort? Third, I asked as my first question, what's constitutional about constitutional rot? Third question is what's American about this account? Because if you look around the world, it's of course a global phenomenon, the rise of illiberalism, authoritarianism, and democratic backsliding. And the phenomenon seems to transcend constitutional structure. So we have parliamentary systems like Hungary or Poland experiencing democratic backsliding just like presidentialist ones. We have federated systems like India and the US experiencing backsliding just like non-federated systems. So is this really a phenomenon that transcends the United States? And to the extent that's right, might it be more felicitously described as something like global capitalism rot rather than constitutional rot? Because if what we're seeing is a phenomenon that really is not keyed to the constitutional laws or structures of any given system, but is global, then maybe we're experiencing something that goes beyond law and really is inherent in the capitalist system itself. Okay, and finally, I'll just ask the most obvious question, our set of questions, I think, which is, what's the cure? How could we possibly get out of this? And here, I worry a little bit about whether the account, Jack's account, is a little too sanguine. I'm not a carpenter, not very knowledgeable about carpentry at all, but my understanding is that if you catch rot early enough, like in your floor, you might be able to replace a floorboard or two and salvage it. But past that point, you actually have to tear up the floor, if not the foundation of the house. And so how much rot do we have becomes relevant there. But more than that, I wonder whether Jack's other big metaphor in the book about cycles, the cycles of constitutional time, sits uneasily with rot, because cycles implies a kind of self-correcting pattern. But rot doesn't go away on its own. It just gets deeper and more corrosive. So there may be a tension there. And here, I think, how we think about the cure links us back to what's exactly constitutional here and what's American here and what's bipartisan here. So if the connection between U.S. constitutional design and the rot we're experiencing is only contingent. And the deeper drivers are really not to do with our constitutional laws or arrangements, but things like inequality of wealth. Then maybe sub-constitutional reforms are all we need. If we just had a policy program that was attacking inequality and broadening opportunity on the order of Senator Warren, say, maybe we could get out of rot. However, if there is a deeper connection between the U.S. constitutional design and rot, then I'm not sure why we wouldn't be talking about Sandy's preferred suite of reforms. That is a constitutional convention, transformative constitutional amendments, Supreme Court reform, maybe Senate reform, Article 5 reform, Electoral College reform. It would seem that we need to actually address the hardwired features of the Constitution if they have more than a contingent causal relationship to rot, but the book doesn't go there. If, on the other hand, really it's capitalist rot, that's the better way to understand what's happening here, then it's not clear that domestic reforms are up to the task at all. Maybe we need to be thinking in Thomas Piketty terms about a global wealth tax or truly transformational, deep transformations to the global system. Finally, if it's really a partisan story, uncomfortable as it is to acknowledge, and one party is much more responsible for the rise in rot and hardball and so forth, then we might be thinking about yet another suite of potential cures sounding in militant democracy. So the last thing I'll say is Jack identifies in the book a kind of paradox of U.S. constitutional design. I don't think he describes it that way, but it strikes me as a paradox where he says we have these features like federalism, judicial independence, separation of powers, checks and balances that he describes as Republican insurance. Republican insurance because they slow things down and they buy time to prevent a demagogue from consolidating all power irreversibly. They allow the system a little breathing room to avoid the immediate takeover from which there'll be no return. The paradox is that those same features of the system tend to produce or exacerbate rot because they make it harder. They introduce veto points into the federal lawmaking system, and they make it harder for Congress to address people's needs. And so insofar as this is a partisan story, really, I wonder whether we have a kind of inverse paradox to confront about militant democracy. And that is the proposition that to get beyond the rot and the hardball we're experiencing, we would actually need more norm breaking, not less, in a future period in which Democrats are in a position to do things like push through a version of H.R. 1, change the apportionment of the Senate, introduce D.C. and Puerto Rico statehood, do a national gerrymandering bill, get rid of the Senate filibuster or what have you. Again, all in the service of creating conditions under which democracy and republicanism can flourish again. Would they have to actually break a lot of norms in a way that would be identified as egregious hardball by the Republican Party? So I'm raising questions, not answers, of course. I'm mainly here to celebrate Jack's formulation, which I find deeply, deeply illuminating. And these are questions that we're all going to be wrestling with for many years. But I think Jack has done an invaluable service in framing the problem in a way that allows us to see what the key questions are. Thank you.
Thank y'all so much. One, for being here. Two, Penny, for inviting me to this conference. It's such a great gathering and opportunity to share thoughts on Jack's work. And obviously, thank you, Jack, for being Jack, because without being Jack, well, we wouldn't be here in this particular way. So I want to talk about constitutional rot for just a few minutes. And part of it's going to jump off of David had to say. More specifically, let me talk about two issues briefly. The first is how our Constitution as a legal document may well lead to constitutional rot. And the second is, let me talk about an application of that vision to partisan gerrymandering that may make us feel as though rot's happening. So unsurprisingly, let me just note Jack's words in terms of defining constitutional rot, because folks might well define it in slightly different ways, but this is how Jack noted it in the Maryland article. It says, constitutional rot is a process of decay in the features of our systems of government that maintain it as a healthy democratic republic. As constitutional rot occurs, our system becomes simultaneously less democratic and less Republican. The political system becomes less democratic because the power of the state becomes less responsive to popular opinion and popular will. The political system becomes less Republican because representatives are no longer devoted to promoting the public good. Instead, they seek to maintain themselves in power and please a relatively small set of powerful individuals and groups. When this happens, the Republican system of representation fails, even as the system remains formally representative in the sense that we still have elections, and the result is oligarchy. Now, the rot metaphor is apt because when I think about rot, I think about gaps in foundations. Gaps in foundations can allow water seepage that can cause wood rot, for example. I am also no carpenter or woodworker, though I have friends who are, some of whom also are constitutional scholars, but we're going to leave that to some. Right? When I think of foundational gaps in our Constitution, I think of that seepage that can cause constitutional rot. Fix the foundational gaps, and we might be able to avoid constitutional rot, or at least the continuation of constitutional rot. However, we may be unable to fix foundational gaps because of how we think about our Constitution. Our vision of the Constitution is as a legal document. And indeed, being a legal document, that may pose an impediment to fixing the foundational gaps to avoid that rot. Now, I realize that the Constitution has legal status. Right? Article 6 notes, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, although some people ignore the and all treaties made, but we won't, or which shall have been made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. Now, that necessarily gives us a sense that the document itself is legal. However, deeming the Constitution to be the supreme law of the land does not necessarily mean it should be interpreted strictly as a legal document. That is, it could be interpreted as a political document instead, and indeed how we characterize the Constitution may affect how we fill its gaps. Indeed, right, some of the Constitution's text is relatively clear, some of it is unclear. Think, for example, of the age of the president being a president needing to be 35 years old as being clear, whereas the Republican guarantee clause may be not so clear. Right, so the Constitution contains pockets of uncertainty, and that uncertainty is created by the unclear text or dearth of text and can create interstices or gaps in the document that must be filled. How the gaps are filled is important. They can be filled through legal analysis or through political analysis or a combination of both. Legal analysis may require that the interpreter consider the remainder of the document to determine what the text at issue means. If a meaning cannot be found, the text may have to be considered silent on the issue or ambiguous and possibly impossible to apply. Conversely, when the text is interpreted based on the political principles underlying the document, the meaning of ambiguous text can become the meaning of the text that is most consistent with those principles, even if that reading may not appear to be the most natural reading of the text. The nature of the document may depend on how those uncertain interstices are filled or have been filled with meaning. If those gaps are filled primarily through textual and legal analysis, the Constitution functionally becomes a legal document with embedded political principles. Conversely, if those interstices are filled primarily based on the political principles that undergird the Constitution functionally becomes a political document that contains legally enforceable rules. All right. So if it's a legal document and we start to say, hey, there's nothing we can do about this because the document doesn't cover this piece of the puzzle, then we may have gaps that necessarily will trigger constitutional rot. If, on the other hand, we always fill those interstices with a political notion or political principles underlying the document, we might be able to put mortar or possibly grout in those particular gaps in order to make sure that the rot does not continue. Right, so keep that in mind as we talk briefly for just a few minutes about partisan gerrymandering. It will just be a few minutes because if you get me started on it, I could talk for hours. Right. So when we think about partisan gerrymandering, we might well think about one person, one vote, which is an equal protection concept that may well trigger an equal protection violation that does not require proportional representation. Now, one person, one vote is extraordinarily clear. There's no question about what it means, and we all should just recognize that. I say that, I'm joking, because Sandy, I imagine, is probably turning red at that, because I know full well that Sandy's position is we're not really sure what one person, one vote means or why exactly the Supreme Court put it there. But nonetheless, one person, one vote is a principle that at least we can state. Whether we know exactly what it means or not is a different story. We also can think about racial gerrymandering and the notion that we have particular doctrines that support the concept that racial gerrymandering is unconstitutional. When we think of it that way, we might well say that, therefore, we can certainly get to partisan gerrymandering at some point and deem it to be unconstitutional. Indeed, folks have been talking about it for the last 40 years or so. But let's think about the notion of how rot comes in and how we may have moved from a situation where partisan gerrymandering was covered to where it now is not. And this is the long train that we think about in terms of how we get from a non-rotten position possibly to one that is rotten. So we could go back to Davis versus Vandenberg 1986 case. Basic legal doctrine that came out of that was that partisan gerrymandering is justiciable. 6 justices said it is justiciable, and that there might be judicially manageable standards. All right. Okay, that sounds pretty good. Fast forward 18 years to Vieth versus Jubileer. Basic legal doctrine, partisan gerrymandering remains justiciable. There are 4 justices plus Justice Kennedy said that partisan gerrymandering is justiciable, although Justice Kennedy did concur in the judgment with the 4-justice plurality on the other side that said that partisan gerrymandering is not justiciable. The notion from Justice Kennedy was there may be some manageable standards, but I can't really find them, and we have 3 or 4 different ways of thinking about it. So why don't we just go ahead and leave it as it is, even though the principle is justiciable? Kennedy just could not agree. So the notion is we can't identify standards yet, so let's punt. But the concept of gerrymandering or partisan gerrymandering was in fact judiciable. Now, fast forward a couple years after that, we get to LULAC, and again, can't find manageable standards. All right, fine. So the notion is for at least about 30 years or so, partisan gerrymandering was judiciable, even though we couldn't quite figure out what it was all about. We then get to Gill versus Whitford in 2018. The basic notion behind Gill versus Whitford was, let's just punt. Why? Because we've got standing issues, and since we've got standing issues, we'll go ahead and punt. Now, some might say that's unfair. Fine. I've been said to be unfair before, but that's pretty much what they did. The plaintiffs, though, had sued on a statewide legislative redistricting plan rather than on gerrymandering of their own districts. So the court said, we're not sure that you necessarily have the standing to challenge the statewide legislative districts. As a consequence, we're going to kick it back to the district court. Okay, fine. Got that done. There were various measures that were offered as ways to measure partisan gerrymandering, but those did not quite work through. Now, Rucho versus Common Cause comes the next year, and the basic legal doctrine from that case was partisan gerrymandering claims trigger a political question that courts cannot decide. We've gone from 30 years prior, having 6 justices saying it's judiciable, we just need to find the standards, to now saying, no, it triggers a political question and we're not going to do it at all. Indeed, the court went through and talked about partisan gerrymandering and suggested that it's not analogous to one person, one vote claims or racial gerrymandering claims. The reason why is that the Constitution, although you got to look a little hard to find it, the Constitution bars all deviations from one person, one vote, and ostensibly bars all forms of racial gerrymandering claims. On the other hand, the court suggests that zero tolerance does not apply to partisan gerrymandering. To the extent that some amount of partisan gerrymandering is allowed under the Constitution, the suggestion is that we can't tell when there's too much political or partisan gerrymandering. And that lack of being able to tell precisely how much political gerrymandering qualifies as too much means it's not covered at all. However, there at least was a little bit of wistfulness involved in the opinion. Indeed, let me give you a piece of from the majority opinion in Rucho that was a bit of a lamentation. It says, quote, "We've never struck down a partisan gerrymander as unconstitutional, despite various requests over the past 45 years. The expansion of judicial authority would not be into just any area of controversy, but into one of the most intensely partisan aspects of American political life. That intervention would be unlimited in scope and duration. It would recur over and over again around the country with each new round of redistricting for state as well as federal representatives." At the end of the day, the court said, we can't fix gerrymandering, but we sure hope that states and Congress will, because this is just a terrible thing to occur. All right, we still at least believe that the Constitution says something about partisan gerrymandering and that it is an issue. Now, I've got a lot of other stuff to talk about, but I got about 40 seconds, so I'll read this quote from the last piece of the puzzle that we want to talk about, and that's Alexander versus South Carolina in NAACP, a 2024 case. Now, remember where we've come from a situation where we had a majority of the Supreme Court saying that partisan gerrymandering claims were justiciable, and Justice Roberts Justice Roberts in Rucho at the end giving a lamentation. This was the beginning of the decision in Alexander. And I'll just read this and I will stop. Quote, the Constitution entrusts state legislatures with the primary responsibility for drawing congressional districts, and redistricting is an inescapably political enterprise. Legislators are almost always aware of the political ramifications of the maps they adopt, and claims that a map is unconstitutional because it was drawn to achieve a partisan end are not justiciable in federal court. Thus, as far as the federal Constitution is concerned, a legislature may pursue partisan ends when it engages in redistricting. We've come a long way, baby, and it's not so great, and the rot is there. I'll stop there, and we'll go from there.
Well, I want to take the first few moments simply to say that I literally can't imagine my personal or professional life without Jack. And so I'm delighted to be here. So the title of our panel, Constitutional Crisis or Constitutional Rot. There's a famous exchange in Winnie the Pooh where he's offered the choice between honey and condensed milk. And his response is both, please. And I think that's the correct answer here. This is a false dichotomy. It's now been probably a decade in which I published a piece saying that the Constitution itself is the crisis. And I believe that ever more deeply. I have no veneration for the Constitution. David is absolutely right. I continue ever more to want a constitutional convention. I think, for example, that's the only way that the problem of partisan gerrymandering can ever be confronted through a constitutional convention, not because Congress has got the power to do something. There's the election clause, and we have the terrible, indefensible system of relying entirely on single-member districts only because of an 1842 act of Congress that could be repealed, but hell will freeze over before Congress would repeal it. And nor is Congress going to propose a constitutional amendment. Therefore, I persist ever more strongly in believing that we need a constitutional convention to alleviate what I think is a really quite terrible constitution. On the other hand, both seeing Jack and Mark Graber, of whom I say the same thing with regard to my personal and professional life, I think rot is also a very real phenomenon. I think it's important that Montesquieu said that in order to preserve a Republican form of government, you need civic virtue. A friend of mine and I happened to be rereading, or in my case, I realized reading for the first time Tocqueville in its entirety. And he begins a notable chapter by saying, well, yes, law is important, but actually mores are even more important. And if the mores go, then the democratic system will go with it, and we'll end up with despotism. And I gather that is really one of the foci of Professor Barnes' keynote address, the extent to which our system can be described basically as despotism, or what Jack and I called a number of years ago a constitutional dictatorship. And it is important to include the adjective there that we don't get a dictatorship through usurpation. We get a dictatorship because presidents constantly push the envelope of both Article 2 powers, whatever that might mean, and more importantly, what Cardozo, now almost a century, called delegation run riot, which is a fundamental reality of American government that has certainly been participated in by both liberals and conservatives. So then there is the current moment that we're invited to talk about, and certain problems with the current moment. And let me suggest, and this represents, something, a new notion of mine, and I don't know how accurate it is, but it's certainly something I'm thinking about a lot, quite literally, these several days. And again, I'm so grateful to have Professor Barnes here, not because of his distinguished career as a legal academic, but because of his prior career in the military. It seems to me that one of the remarkable features of the American Constitution, and for that matter, most constitutions around the world, is how little they have to say about the military. And the extent to which the military presents really, really interesting problems. If Max Weber is right, that what defines the state is a monopoly over the legitimate use of force, then you have to say, okay, who actually controls the force? One might say, well, it's the president, the commander in chief. But actually, that's not true. The president doesn't pick up the gun. The president doesn't fly the planes or send out the boats. It is military officers who have to do that. And then that raises a very, very important central issue in the way we define our constitutional order, which is civilian control of the military. Now, there are two questions. One from a political, well, both of them from a political science perspective. The first question is, why exactly would one expect the military to adhere to civilian control? They have the weapons. They also have their priors about how a society ought to run. So this is the classic principal agent problem. The problem of the administrative state. And perhaps we ought to view the military as we view the problem of the administrative state in general. The administrative state arises for extraordinarily good reasons that we can no longer tolerate government by amateurs. We want people who actually know things to make public policy, whether it's which drugs are safe, what is the proper level of interest rates at the time of inflation, or a not a sufficient labor market, et cetera. We just go on and on and on. And one actually wants military professionals. Even Thomas Jefferson agreed in 1804 that we needed a national university called West Point. And those are the only national universities we've got in this country, the military universities. So you have a trained cadre of professionals who are supposed to follow civilian orders. So one question simply, as I say, why would you expect that? One answer is extraordinary loyalty to the Constitution, and I'll return to that in a moment. But if professionals develop the view that those in charge of the polity are accurately described at best as amateurs who really don't know much, or at worst as sociopaths who are corrupting the government for their own ends, that is a complete lack of civic virtue, a complete capitulation to a politics of self-interest. Then it's not simply the kind of social choice argument of why do you expect agents to follow the orders of principles if agents can benefit from doing whatever they want, but why would you expect trained professionals to follow the orders of people for whom they have contempt? And it seems to me that that is, in fact, the most important single question facing the constitutional order, literally at this moment, where we are in not only an illegal war, which is a question of interest to lawyers, but also a crazy war, which may or may not interest lawyers, but it certainly interests everybody else. And so imagine that our crazed president had followed through on his threat to obliterate Iranian or Persian civilization. He can't do that unless trained military professionals drop the bombs. So what do you want the trained military professionals to do if they're ordered to drop the bombs? Do you want them to say, I live in a constitutional system that says we obey all lawful orders. So let me ask my lawyer if it's lawful to drop the atomic bomb on Tehran. And I assume that lawyers will differ because we differ about everything that it arises actually in the course of politics. And we have Harry Truman, who ordered dropping the bomb not only on Hiroshima, but more relevantly in terms of some of these debates on Nagasaki. And so you ask the question, is the only question lawfulness and unlawfulness and who gets to say? Or are there other questions as well, such as gross immorality and the like? And so it does seem to me that one of the questions that is presented us right now is actually the level of our commitment to civilian control of the military, because that is based on a variety of priors that civilians can be trusted, to trust either because they have the right dispositions, even if they don't know much, or they are authorized, correctly, rightly authorized in terms of what we mean by Republican form of government, to give orders, even if the professionals disagree with them, because overall we're better off accepting the orders of people who really don't know much about what they're doing. And that, it seems to me, is questionable. Now, one last comment, and this picks up on Professor Morisco's response to Professor Bart's, and that is that everybody takes note of the Constitution. That's true. And it's really, really interesting because one response that I have as a lawyer and as a political theorist is that we have no idea what the oath to the Constitution really means. It's void for vagueness. But one might say, no, that's just too pessimistic. And a lot of people really do think they know what the Constitution means, including law professors. But that's also Timothy McVeigh. Timothy McVeigh is an extraordinary, interesting person in terms of assessing the meaning of our constitutional order, because Timothy McVeigh justified his indefensible terrorist activity by virtue of the oath he took as a soldier to support, protect, and defend the Constitution of the United States against all enemies, domestic and foreign. And his view was that the American government had indeed become rotten, and it was his duty as somebody who took his oath of loyalty seriously to do whatever he could to rectify the system. Now, I presume that all of us think that this is crazy. But is it crazy because that particular terrorist act was thoroughly indefensible and crazy, or because we just want to dismiss the very possibility that if one does take an oath of loyalty to the Constitution seriously and believes that one knows what that means, such as preserving a Republican civic order, constitutional order against sociopaths, then, what David says is actually very, very serious. What does it mean to act in order to preserve a constitutional order? And the very last thing I would say is that everybody ought to reread Federalists 1 and 40. Federalist 1 is about whether we as a collective people can engage in reflection and choice about how to be governed. And I think most of us say no, because I think the central attack against having a convention is based on a fear of our fellow citizens, and God only knows what they would do if they actually engaged in a convention. Then in Federalist 40, you read James Madison explaining how it is that the framers thought that what Michael Klarman calls a coup against the existing constitutional order, that is the imbecilic Articles of Confederation was necessary because they had the proper disposition, and that proper disposition included, among other things, simply flagrantly ignoring and shelving the crystal clear requirement of Article 13 of the Articles of Confederation that any amendment receive the assent of all of the legislatures of all of the 13 states. That's why the most important single article of the Constitution is one that we never teach, Article 7, saying that this Constitution becomes valid when ratified by the conventions, not the legislatures, because the legislatures would never have ratified the Constitution, and 9 states. 9 isn't 13. So it seems to me that our constitutional history is extraordinarily rich and extraordinarily troubling, particularly at this moment.
I've been taking extensive notes here because I can teach my whole con law class based upon what the other panelists have commented on, my whole class for the whole semester. I want to thank Penny Andrews and Dean LaPiana and New York Law School for putting together this conference. It's not only timely, but it's an appropriate subject matter. I think Dr. King said it best. We are confronted with the fierce urgency of now. In this unfolding conundrum of life and history, there is such a thing as being too late. I think this conference helps us to make sure that Dr. King's words are not going to be applied to current things going on in America today. I would slightly disagree with the keynote speaker, Professor Barnes, just slightly, because Professor Barnes said that he thinks that there are some answers in this room. And I would say that I have no doubt that there are some answers in this room about the problems that are going on in our country today. I have no doubt. I look at Penny Andrews there. We go way back to South Africa. And of course, South Africa had some serious constitutional issues, right? And they didn't blow things up. They're still working on those things today. The reference to the captain in Vietnam that was asked by the press why he destroyed the village, and he said, I destroyed it in order to save it. And so for me, we don't have to do that. I'm confident that we're not going to do that. I think we're going to save this place. And I think that we owe Jack Balkin a great debt of gratitude. I don't know if it's rot or if it's crisis. I'm not sure which one it is. I mean, some of the panelists have talked about it. We'll take both, right? But I do know that there are some answers in this room. And we owe Professor Balkin a great debt of gratitude. He laid out his definition of rot. Said we're not in a crisis, but we got a whole lot of rot. I agree with him. We do have a whole lot of rot. My fellow panelist, David, identified the fact that we need to get the rot early. And I agree with him. We need to get the rot early, but we also need to get to the termites and the mold in that rot. So I'm going to talk about, that's what I'm going to talk about today. Professor Barnes focused us on the executive rot. And, you know, there's a whole lot of rot to go around. We can talk about all the Congress rot and Supreme Court rot, but Professor Barnes focused us on the executive branch, so that's what I will stay focused on. Due process. Professor Barnes talked about ignoring court decisions and said that, you know, generally there's a norm that, you know, that's not what is done under separation of powers. That's not something that should be done. And I think that I would agree wholeheartedly with Professor Barnes that we don't want the president to set the norms. I don't know, maybe the Pope I'm not Catholic, but maybe the Pope, man, we'll get the Pope to set the norms. But I definitely don't want the president to set those norms. But let's talk about the due process norm. Professor Barnes said we're not supposed to ignore, the executive branch is not supposed to ignore a Supreme Court decision. And when you think about the practices of ICE with respect to due process these days, and those practices are way in violation, I think, of due process norms. And of course, sometimes they lead to murder of Americans or individuals who are here in America and deserving the protection of the Constitution as well. So when I think about ignoring court decisions, and I know earlier it was brought up about birthright citizenship, we'll see what the court has to say about that. I hope that they will reaffirm Wong Kim Ark from 1890. But in terms of ignoring Supreme Court decisions, I think President Trump's practices with respect to ICE go way back to 1841. You want to talk about ignoring due process norms? 1841 is when the Supreme Court set the case. I mean, I look at Kilmar Abrego Garcia, and I say that case was decided. It was decided in 1841. And I know a lot of you are saying, Professor, you're a little crazy today. What the heck are you talking about? I'm talking about the Amistad decision. I'm talking about Sinkay. I'm talking about 40 individuals who were wrongfully enslaved and who were taken to court in New Haven, Connecticut in 1841. And you know what happened? The Supreme Court said, hey, wait a minute. These individuals were wrongfully taken. These individuals, and then the president tried to send them down to Cuba. And the facts that the court heard were they're from Africa. They're not from Cuba. And the president said, I don't care. I'm going to tell my U.S. attorney to appeal the case to the Supreme Court because I want to send them to Cuba. And the Supreme Court said, no, you can't do that. After a number of Americans provided legal assistance to these individuals, and John Quincy Adams, a former president, stands up for them in the United States Supreme Court and says, if you allow these individuals to be denied their due process and to be sent to Cuba, the next thing that's going to happen is they're going to be American citizens that the same thing is done to. And John Quincy Adams says, are you going to let this happen? And the Supreme Court says, no, we're not. So in 1841, the Supreme Court says this, but Donald Trump doesn't seem to be prepared to follow that precedent. When you think about rot in other branches, and it was mentioned about justice. It was mentioned about Attorney General Garland, and I was a slip of the tongue, right? Justice Garland. It was mentioned about Attorney General Garland, and it was referenced earlier that Mitch McConnell and the Republican majority Senate was playing hardball. And some characterization, I think Professor Barnes mentioned a characterization by another professor that was hardball. And I started to think about that. And I played a little baseball. I love baseball. And I started to think about that, and I said, no. There's playing hardball, and then there's stealing second base, sliding into second base, and sliding in with your spikes up to hurt the second baseman from the opposing team. And to me, it's not a hardball reference. It's McConnell sliding into second with his spikes up. And what happens when you do that? All you baseball players know, the bench clears, right? The players come out of the dugout. And so when I start thinking about that episode in our history, the hypocrisy of looking at the rules, right? Looking at our norms and saying, oh, I'm gonna slide into second with my heels up and see if you feel hurt then. That's the highest form of hypocrisy. That's the highest form of rot. When Mitch McConnell says, you know what, I'm gonna give the opposition president, I'm gonna say, 11 months, that's too short of a time to the election. So you can't have a constitutional right to appoint a Supreme Court justice. I'm going to stop that. And then Amy Coney Barrett is appointed 2 weeks before the election. I think that sliding into second base spikes up. I mean, who am I? But I'm just, making a judgment in terms of prioritizing rot. I think that's pretty much there. In terms of what have I got? 2 seconds?
A couple minutes.
A couple minutes. Okay. So couple final thoughts then. In terms of the solutions, and I always tell my students, look, we can criticize. I work for a federal judge. I clerk for a federal judge. He was like, you can criticize me all you want in terms of your drafts, my drafts, and your critique of my drafts. You can criticize all you want. But he said, if you're going to criticize, you better have a way to do it better. And if you don't, then, sit down and shut up. I work for a tough judge. But so I will say this, in terms of solutions, I listened to Doris Kearns Goodwin this morning, the author, presidential historian, talking about the 60s and how we got through that. And when I think about constitutional rot, to me, the most problematic rot, and there's a lot to go around, but the most problematic rot is the rot in the people. Less than half of us even vote. And the people that say, oh, it doesn't matter. I got so many of my students, they say, oh, professor, I'm teaching con law and race in the law. And you're going to sit there and tell me you didn't vote? And you're slapping your parents and your grandparents and people that fought and died in this country that you'd have that right to vote. And they don't do it. So there's a lot of rot to go around. I think I'm much more positive than a whole lot of people, including Professor Balkin, maybe, and some others in the room, because I do believe that we're going to get through this. I do believe that we're going to deal with the rot. And I actually do believe that we're going to be stronger for it. And so I'll leave it at that.
So I want to open it up to questions, and I'm going to ask the first one. And I want to kind of call a question that David raised about what's actually constitutional here. And I want to focus in some ways on the fact that we haven't really talked about the exogenous forces that are attacking constitutional systems around the world, right? We look at the internet, we look at globalization, we look at climate change, we look at income inequality. Any one of these knocks Ulysses off the mast. All four are a tidal wave. You change how we communicate, how capital flows across borders. You change our lived environment. You create a new regime of haves or have-nots. Over the course of a couple of decades, without a real plan, this is going to be enormously dislocating to constitutional systems and constitutional institutions, particularly those that were built in the shadow of the Great Depression and World War II. And so I guess my question is, could any constitutional design choices have been resilient in the face of any of this, right? Are there any constitutional institutions that could possibly survive these sorts of simultaneous, unprecedented, exogenous attacks on some central assumptions about how our systems work. That's the question that's kind of lingering in my head, which is there any sort of constitutional mechanic work that can be done or that anybody could have done in the face of all of this? So I don't know if anybody wants to take that on, but that's sort of where my head was going in the midst of this conversation.
Yeah, I could start by touting an essay that will appear in a book that Mark Graber, Mark Tushnet, I, and a young Italian scholar are editing, called Constitutional Democracy in Crisis, ? It's an essay by Ron Herschel. What he argues, I think quite convincingly, is that we should liberate ourselves from the Westphalian paradigm that we have assumed now for coming on to 500 years or 400 years, that it is natural to divide the world into nation states with their separate constitutions, their autonomy, their sovereignty, whatever that means, et cetera. And what he says is that, he cites climate change in particular, but that more and more problems are transnational, international, and simply can't be solved in the nation state. So you look at our own constitutional history. Our 1787 Constitution was written for a certain kind of political economy that collapsed certainly by the time of the Great Depression. And whether or not you're confirmed Ackermanian or not, it does seem to me that we get a new political regime as a result of the New Deal, which recognizes that the old idea of local commerce, et cetera, just is no longer sustainable. And what Ron argues, that same thing is true of the international system. So one answer to your question is no. That's so long as we think of national constitutions, we're kidding ourselves if we're looking for a perfect design or even a satisfactory design.
Anybody else want to weigh in?
I'll wait.
I'd like to open it up to questions. Let's start with Mark Graber over there.
Posterity. Yes. I want to start with David. Started to explore a little more. What's the difference between constitutional rot and a rotten regime? And consider, I've always regarded Sandy as the prophet, the John the Baptist of the Trump administration, because I'm firmly convinced when we open Truth Social, Sandy's going to say, Trump will say, I've read my Federalist 40. Yeah, we didn't do it the way they did it, but we've established a new regime. And Sandy Levinson teaches us that way we did it, a perfectly legitimate way through the election. And perhaps in this vein, might constitutional rot be the incapacity of a political regime to achieve the governing goals marked out by that political regime, and a rotten political regime be one that has rotten goals? If so, I think we're now in a rotten political regime rather than a regime suffering from constitutional rot.
Sure. You may be right. I'm not sure. I keep thinking back to the notion of mores, civic virtue, et cetera. And I think the point that Michael made about spikes high is an interesting one. It reminds me of something a little bit different now that we have a Homeland Security director who used to be an MMA fighter. It reminds me of situations where one MMA fighter has knocked the other out, but the referee has not stepped in. And the question is, do you hit him again? It's within the rules to hit him. But if you really want this thing, and I'm not suggesting that I do want this thing called MMA to continue, but if you really want it to continue, it's not clear that you can just keep hitting people. Because at some point, someone may say, "Yeah, we're gonna do away with this." So in some ways, what we define as being outside of the bounds, even though it is technically not prohibited by the Constitution, may be what we call civic virtue. And it may well be that if we no longer are civically virtuous, which may get into the question of once we allow people to have the kind of super fortunes that exist, we may no longer have civic virtue. It may be that that's what is going to do us in, which may then get into the question of should we go away from the concept of having national constitutions? And I'm not sure what the answer is, but maybe there's something there.
Yeah, just one very quick comment. Levitsky and Ziblatt talk about the importance of forbearance. And what forbearance means by definition is not exercising every ounce of your legal entitlement. And one of the things we do as law professors, for better and very much for worse, is to teach our students that their duty is to engage in zealous representation for whoever hires them as a client. And the notion of forbearance becomes an almost unlawyerly sort of virtue.
Mark, I'll just say quickly that I think this proposed reformulation of ROT, the incapacity of a duly elected regime to achieve its goals or its program, as defined by the regime. I mean, on the one hand, it's a little, it's more crisper and more tractable, perhaps, than looking at how democratic or Republican the system is in a more diffuse sense. But here too, I just think we run into these causal questions. So why can't the regime achieve its stated goals? That could be a story of veto points and the difficulty of running the gauntlet of American bicameralism and the presidential veto and judicial review and the filibuster. It could be a story of the political economy of lawmaking in this country, and that's goes beyond constitutional design. It could be a story of a kind of geographic mismatch between the problems. I haven't read this Rand Herschel essay, but being global in nature and the constitutional systems being domestic. So once again, I just think we kind of need to fix our causal story, however we define rot, to begin the process of prescribing a cure.
I'm going to take 3 questions at a time, so that with lots of hands up, and if you can just identify yourself and keep your questions short, please. Thank you.
Let me make a quick comment.
Who are you?
This is
By yourself.
Jeff Renz, retired. I'm glad to see you all because I've spoken to you many times on the listserv. Hank, you talk about the cracks, and I would suggest that the problem in the cracks isn't fungus or water, it's money. It's money. And there's no way around that until we make a change to Citizens United. I want to go another step further and talk about reapportionment and voting rights. When the Memphis case, when the Hartford, Connecticut fireman's case was decided, I'm scratching my head and I'm going, what's going on? Because the Chief Justice making these comments and I'm going, he doesn't get it. So I sat down one day and I asked this question: how many Black classmates does the majority have in their background? And this is when Scalia was still on the court, Kennedy was still on the court. And I went to their high school yearbooks and I counted the faces. And we're talking about thousands of classmates. Thousands of classmates. Anybody want to guess how many Black classmates I found? And this includes Justice Thomas's school. 17. 17. And why is that? Because we don't have a leveling system here. I've got to praise Justice Sotomayor because she hit it right on the head. Okay, let me move on quick because I know you want to. Sandy, not only McVeigh, Stuart Rhodes, who was the head of the Oath Keepers, a guy I met back in 1999 because I was in Montana. He was in Montana before the Montana Supreme Court disbarred him. And he belongs to one of you guys from Yale. So Stuart Rhodes is an example. He's a former paratrooper. Anyway, I think that's all. There were some things I want to say, but I'll pass it.
Thank you. David?
Hi, thank you. David Simpson. I teach here at New York Law School. I think this is sort of at the intersection of what people were touching, everyone was touching on, which is sort of a question that Donnie always asks us to think about in the faculty colloquium, who decides question. So if we have these debates over what is the causal story, what exactly is the problem, and also solutions, is there somebody at the end of the day has to have the authority to make the final call or the final word on that question? And in some ways, do we have an identifiable or even a preferable institutional allocation of that we can find somewhere? Can we find it in does the Constitution even speak to, for example, the question whether this is a constitutional problem or not in terms of who gets to decide? I was just wondering if people have ideas about that.
Thank you. I want to go to, sorry, Heinz Klug, to Sandy's question about the military. So here's an interesting issue. We've had many military coups in Africa, and what the coup leaders do the moment they take power is they say to all members of the executive, please report to the local police station, you're going to jail. To the members of the legislature, just go home. And to the judges, they say, stay where you are and carry on working. So the question is yes, the military professional has a belief in what they can do, but they also understand they can't actually run society. They need the judges to do that while they're doing what they're doing. And what are the implications there in terms of that idea?
All right.
Anybody want to respond to any of that? Sandy?
Yeah, I'll point out that the Turkish constitution, which is quite a remarkable constitution, the military has tended to view itself, to describe itself as the guardians of the constitution against Islamization, because the 1922 constitution is probably the most secular constitution there is, except for one or another of the communist constitutions nobody ever took seriously. Just a kind of a factoid. With regard to the final authority, I mean, the first book I wrote was, developed the difference between what I called a Protestant and Catholic view of authority. And my view is that, no, I'm a constitutional Protestant. And it seems to me that the dilemma of Federalist 51 is that it sets up, ambition countering ambition, constant game of badminton or tag war, the game without any rules. And it is up to those with enough pluck and luck to be viewed as the final authority, because the Constitution just does not say that we have a papal Supreme Court. Even if you believe that Marbury's correctly decided that judicial review makes sense, a close reading of Marbury, want to do that, does not suggest that the Supreme Court is the law of the land. It's that the Supreme Court is in fact authorized as a court not to validate things it considers unconstitutional, but then you have departmentalism. And I don't think there's an answer to that except through politics.
Just two quick pieces of the puzzle. Jeff, you have money. I agree. Money's an issue. Of course, it's hard because obviously some of the stuff that I do is voting rights. One of the arguments that I raise with my class is whether government is designed, or at least whether our government was designed in order to protect property. And if the answer is yes, it's kind of hard to view money as being a bug. It's just a feature. It's just what we do. So it's kind of hard to complain that money gets into the system when that's kind of what the system was there for. But I think you raised some great pieces of the puzzle. On the military piece of the puzzle, just one quick story. I used to teach the Constitution at the Federal Executive Institute in Charlottesville, where we had essentially GS-15s up through the SES, and I would go there and talk about the Constitution, and we would discuss the Constitution. And part of what was fascinating was that the folks who had a military background seemed to actually be willing to stand up in defense of the oath more than folks who were not in the military. It was actually quite refreshing and a little surprising. That is to say, folks who had not served oftentimes said, well, if my supervisor told me to do X, then that's what I've got to do. And folks who had a military background said, are you insane? Well, okay, they didn't put it that way, but close. Because they said, of course, we always have to worry about whether the orders we're given are lawful or not. So it's not okay to just say, oh, well, my boss told me to do it, so I did it. And I always found that to be quite interesting, that the non-military seem to feel one way versus another. Last piece of the puzzle, in terms of who gets to decide, it's an interesting question, because we might well say, in theory, the people are supposed to decide. And if we take the Declaration more seriously about the people's role in revolution, even though it's not clear that the people in 1776 in that time period were really justified in claiming what they claimed. But if we take the people as being the folks who are supposed to take care of this situation, arguably the people are the last ones to decide, both in terms of revolution, but also arguably in terms of juries. So there are a couple of pieces of the puzzle there, but I think it's a fascinating discussion.
I'll just briefly. Oh, I'm sorry.
Go ahead.
This follows on that, so I'll just be very brief and say on the who decides. I just observed that it seems like Jack talks about the cycles of constitutional time. There's some kind of cyclical process of which institution critics of the regime or progressives, we could say, want to be the final decider. And so, very crudely speaking, we could chart a movement among liberals, progressives over the last century or so, from judicial supremacy in the Warren Court to some kind of executive supremacy that you saw in the Obama era, say, to now congressional supremacy seems to be the preferred remedy to Trumpism. And you have people like Jack's colleague Sam Moyn and his co-authors and Nico Boy at Harvard talking about the need to restore legislative supremacy as the answer. What's lost in this neo-legal process cycle of trying to find the right institution to be supreme, I think, is a vision of popular sovereignty that would have been legible to the framers as maybe the most fundamental form of constitutional rot, which is the failure of each successive generation to really grapple with the content of its fundamental law. If that's the only way out of this kind of quixotic cycle of trying to find the right institution to govern, then I think we are in Sandy's world of having to think about conventions on a national scale, or conventions for state constitutionalism, or juries, or the institutions that more directly empower ordinary people.
Your question and comment actually about money in politics triggered me to think about something I ask my students all the time, and that is, if there was one case that you could reverse, what would it be? And that's something that I grapple with. That's nightmares, keeps me up at night because there's so many cases. And I think about, McCleskey versus Kemp death penalty case. I mean, if I could reverse that one, and you got two justices saying they made a mistake, and you make a mistake, you definitely don't want to make a mistake in a death penalty case, right? And then I think about Trump versus United States. The president should not be above the law, and that's something. But I think your comment really focused me on, if I had to reverse one and only one, it would be Citizens United. You get the money out of politics, and maybe then we could start coming closer to, having all the people have a little bit of power.
Gaurav Mukherjee, University of Connecticut. I wanted to quickly push on the provocation that this might be a crisis of capitalism. And if that is fundamentally the crisis, and it's not merely of constitutional order, I was wondering whether the language of rot does it clarify or does it mask rupture? And I'm wondering whether it risks constitutionalizing, as Dave suggests, what should be understood as a breakdown in the material settlement that once made constitutional democracies seem stable. And if there are emerging forms of post-capitalism that we're seeing, how does constitutional law, how do newer forms of institutional arrangement respond to that?
Mario next. It's in here.
Thank you. So this question goes to Professor Levinson mostly, but I'm interested in hearing others. I served for 23 years in the military, 2 Republican and 2 Democratic presidents, and it mostly didn't matter. A little bit during George W. Bush and the war on terror. Not that we were constrained in the legal advice we could give. He just wasn't as interested in it as that of others who were more consistent with his own values. But we were never told that we were not allowed to defend the rule of law or to provide what we thought were legally and morally sound advice. But when you ask sort of now this question of what happens in a world in which those folks have taken an oath and now the leadership seems to be not so equally constrained by it, what we have mostly seen is, and I really regret this, resignation, right? Which is, if you look at Vice Admiral Halsey, who was the admiral in charge of Southcom, says, these are violations of international law and I will resign rather than condone them. If you look at the Army Chief of Staff, Randy George, who just stepped down, it turns out that was mostly about him wanting to promote folks who he said were meritorious, but because they happen to be women and people of color, and that's in a message of DEI, that he got crossways with the secretary. And so a person whom thought to be excellent and a meritorious example of a great leader steps aside. And my question to you is there power in this resignation? Is it actually signaling that the rot has gone too far and that we must do something? Or is it simply giving in and then, replacing them with folks who will be more pliant, and which then feeds the rot?
Thank you. One more. Professor Burkhalter.
They do this stuff. Hi, I think this touches on a lot of what's been discussed or asked. And my question is, to a certain extent, and this would be for anyone, as opposed to a constitutional crisis or rot, what about the theory that, generally speaking, neither exists? Rather, the rot or crisis is within ourselves, meaning society. So in other words, let me posit that the United States Constitution is possibly operating as intended. It was drafted by white men who owned other human beings as property and did not see anyone other than European white males as their equal. And further, the United States Constitution doesn't necessarily preclude any one group from seizing power of all 3 branches of government, right? There's an attempt to balance. So, and to Professor Barnes' point, certainly no one has necessarily stood up and said, I disagree. And when they do, if they are in power, really haven't exercised much of a power. So perhaps the crisis and rot is in those, perhaps over half of this country, who have voted for our elected officials with full knowledge, right, looking at Project 25 and elsewhere, of what was going to occur. Someone put all these folks in office and someone is standing somewhere clapping and saying, job well done. So once again, the question being, perhaps the Constitution is operating as intended and the rot or crisis is within ourselves. So I'm curious in your opinion.
I mean, there's a lot of there in those questions and comments. I would just quickly say that I think, part of the problem is we've lost our moral compass. And when Professor Barnes talks about the military, I can tell you, I mean, I might be naive, but I was really shocked by the torture stuff that occurred. I thought we had kind of passed that, and when our, military after 9/11 and the CIA and others were involved in torture, it kind of shocked me that we actually would do that. And so I say we've lost our moral compass. I think about the Saturday night massacre, and I think about individuals saying, I'm not going to do that, Mr. President. And then a second person says, I'm not going to do that either. And so I say we've lost our moral compass because when somebody steps down on principle, the next person up needs to do the same. And they need to go down the line until eventually they say, wow, we can't find anybody to do it. And so I don't know. I mean, maybe that's very naive, but for me, that is something that that's one of the ways we get out of this predicament. We got to get out of this problem. And so maybe I'm hoping a little bit too much, but I think if the president issues some illegal orders, I mean, I was very proud of the fact that we had some Democrat senators and Democrat congresspersons, say don't follow an illegal order. I mean, there's a whole lot of other people that should be saying the same thing. And that's the problem. Next person up needs to say, I'm resigning too. And so I don't know, maybe I'm naive and I'll hear what my fellow panelists have to say. But to me, that's the problem.
So I'll make it quick. Just one more story about the class I used to teach. It was a 4-hour class, which folks at the beginning of it were like, oh my God. And luckily I had a good hype man to start by saying, no, it's really great. We started with the oath. That was the first thing we started with. We always start with the oath. And at the very end, we would go through examples or hypotheticals where I would ask, what would you do in this situation? And because we were talking about both oath requirements as well as ethics, oftentimes people say, well, I would resign before I did this because this is what when my boss told me something that I didn't want to do. And the question that usually got folks talking again was when I said, why would you resign? You're doing exactly what the oath tells you to do. Why would you resign? Make them fire you. Now, I recognize that from a practical perspective, it's better to resign than be fired. But the point is, you don't leave because somebody tells you to do something illegal. Arguably, you stay and fight. And at least maybe the person who fires you has to spend some political capital, which may then over time get folks to say, no, the person at the top is the problem. Whether in this election, the next election, or possibly impeachment, what have you, arguably that's part of what's going on. So that's one piece of the puzzle. In terms of capitalism, it does go in part back to property, but I think where it also goes and where I tend to have a problem is with the concept that we now seem to believe that the people who have made that kind of money somehow deserve it, as opposed to recognizing that what they've taken is their gains to trade. Oh, Lord, is capitalist calling me again? Oh, my God. As opposed to recognizing that the reason why they have what they have is in part because of the society that exists, particularly in America, that is safe and allows them to make the money in that particular way. And if we rethought the question of how much of the money is really from them as opposed to functionally from society, which they have extracted from society, then that might well get us to start thinking about how to change a taxation system that also might get folks to think about what it is that we as an American society is supposed to do and how the American government is supposed to work. But that may well be pie in the sky. But at least on the resignation point, I'm still standing behind that.
Yeah, with regard to actually the first and last comments, and that's also what Hank was saying, that, I mean, the mystery with, say, Montesquieu, the argument of civic virtue, is that it requires, or it might require transformation from a fallen self to a more virtuous self. The fallen self is the one that's interested in self-interest alone. And to tame self-interest by some notion of civic interest, and is that a realistic model? And what if it, isn't? So Um, I've been angry at Bernie Sanders since 2016 because he's run for president twice, and not once did he educate his young followers, who quite frankly know nothing about the way the American political system works or any of the intricacies of the US Constitution, that in order to achieve his self-described revolutionary agenda, that might require some constitutional reform. But one explanation for that is that he really does believe that the crisis is a crisis of capitalism, is a crisis of the economic system. And, I don't know exactly what kind of Marxist or socialist he is, but certainly the classic view was that what we spend our lives on is simply epiphenomenal. The fundamental reality is the class structure. And there's a lot to that. And so, how important are constitutional forms? I'm really not sure. I think they're more important than a lot of people think, but it would be foolish to argue that, design the right constitution and you just generate the right outcomes. With regard to the oath and fidelity and stuff like that, one thing is disobeying illegal orders. But as we often hear, the scandal is very often what is legal, not what is illegal. So you mentioned 1841 in Amistad. I fixate in my teaching in 1842 in Prigg versus Pennsylvania. And my view has always been that if you can stomach Prigg, Dred Scott, it's not a serious problem. And Joseph Story in 1842 writes a letter to a friend saying, remember Joseph Story, Harvard professor, et cetera, writes a letter to a friend saying, I'm anti-slavery, but I've taken an oath to the Constitution, and the Constitution didn't quite put it this way, but we can. The Constitution is pro-slavery. William Lloyd Garrison got it right. And my duty as a faithful judge is to enforce the understanding of 1787. You can call that originalism, if you will. And therefore, he writes the all-time implied powers decision that puts McCulloch to shame with regard to the fugitive slave law. And so, you've got two models. One is the legal officer who says, you're asking me to do something illegal, what should I do? But we also have to address what awful things the Constitution allows and what you should do. So the very last comment I want to make, my favorite writer now on American politics and the Constitution is David French in the New York Times. And French had a remarkable column last week on the threat that Donald Trump poses to the military, because whether or not they will obey his illegal orders, but also whether they will obey his legal orders. So I would point out a really great article just published in Northwest Law Review by Josh Braver, University of Wisconsin. It's probably now legal history, because he's writing about the teaching of professional responsibility at West Point prior to Pete Hegseth's arrival. But what he points out is that professional responsibility is taken far more seriously at West Point than it is at any American law school. And that what the professional responsibility course taught was not only the responsibility to disobey illegal orders, but actually to take morality into account so that an honorable military official might resist a legal order that was grossly immoral, grossly disproportionate, et cetera, et cetera. This is obviously very both interesting and problematic, and really does raise the issue of what we expect military professionals to do. In his column, David quotes Douglas MacArthur, as, certainly the warrior general who says that a professional military person protects civilians. And, is that an issue of law or an issue of morality? And who says, and what should be inculcated in military professionals when they're faced with civilian superiors who have no interest in protecting innocent lives?
Take it just 10 seconds.
The last word before we speak our
Okay, give me just 10 seconds. Just want to say one positive additional word about grand juries and the notion that they're doing some interesting stuff as well. We're working as they're supposed to. Obviously not a sufficient bulwark, but they're working as well as they can.
I'll briefly just say that, so Sandy asked, how much does constitutional form matter as compared to class structure? And if you look comparatively, you can find some correlations, like systems with proportional representation tend to be more redistributive than those that rely on simple majority votes. Same with unitary versus federated systems. But the correlations are pretty weak. And I think it's genuinely unclear looking across the world how much constitutional structures drive outcomes. I'll just note that Jack's, and this connects to Gorov, Jack's story of rot and renewal and cycles, it strikes me hearing these comments is quite different from the more common narratives with which we tell our constitutional history. One is a narrative, the last question got it, of return. This was always meant to be an inegalitarian, exclusionary system. And Mike Klarman was cited earlier, Charles Beard, we're, in a sense, there's nothing new here. The more common narrative is one, of course, of progress, that the arc of constitutional history has been for justice. Every amendment has included more groups in the franchise. No amendment has cut back on rights of inclusion or participation. The constitutional moments that we've had, if you will, had the same character. We've had one Reconstruction, then a second Reconstruction. So all of which is just to say, a narrative that's neither one of fixity nor one of progress, but one of cycles, rot and renewal. I think what that calls to mind is accounts of capitalism, because the best known accounts that I know of kind of cyclical tendency toward crisis built into the system are kind of Marxist accounts of capitalist development. So if Jack is kind of, in a sense, giving us a quasi-Marxist account of American constitutional development, does it ironically actually push us away from the Constitution as being a particularly relevant variable here as compared to class structure and capitalism?